though. A lot of people have drawn up a will, and I understand that wills are not completely adequate. And I've heard the term trust thrown around quite a bit. What is the difference between a will and a trust?
Well, that's a great question. It's a cause of a lot of confusion. There are a lot of documents that all have similar names that nobody really understands what each one does. A living will, a living trust, a last will and testament, and people don't understand that each document really does its own thing. Now, a will is given to you by the state if you don't have one. That's the one document where if you don't describe how you want your assets to be distributed when you die, the state will describe how they want your assets to be distributed when you die. And so it's not ideal, but you will have a will eventually. The only reason to just have a will is if you don't have any assets, but you do have minor children. So if you have minor children, and you want to put a guardian in place, but you're renting your apartment, you're leasing your car, you're living paycheck to paycheck, that's fine for now. You can put a will in place, and you can at least have that guardian in place for those minor children. But that's pretty much all a will does, because a lot of people think wills avoid probate. They do not, and probate is the transferring of assets through the court system from the deceased person to the living beneficiaries. All wills must be probated. In fact, probate is the proving of the will. The only way to avoid probate and to actually add protection for those beneficiaries is to use a living trust. Now, there are many different types of trusts, both revocable and irrevocable. The type I just want to talk about today is the revocable living trust. The living trust works in concert with the will, so it's not something that is in a vacuum. It actually, the will helps to fund the trust. The trust then has all of the assets. The assets avoid probate. They will reduce or eliminate estate tax. They will allow for asset protection for all of the beneficiaries, and they will allow the grantor, the person who creates the trust and gives to the trust, to control assets in Florida for up to 360 years after they die, which means that for all those people concerned that I might give something to my daughter and then my son-in-law ends up with it, he won't. You'll be able to give assets directly to your children, then your grandchildren, then your great-grandchildren, or anyone else you want to give it to, charities or friends, whatever you want. But you'll be able to control where those assets go long after you're gone.